Well, good afternoon, everyone. I noticed that the conversation was starting to diminish, so you clearly think that it's time to start, so I'll take that hint. Welcome all to the Human Rights Commission, the Australian Human Rights Commission, another in our RightsTalk series, Balancing the Scales of Justice. And I want to begin by acknowledging the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation. My name's Graeme, and for the next 15 days, I'm Australia's Disability Discrimination Commissioner. After that, who knows? But Australians who need communication supports or who have complex and multiple support needs are not having their rights protected and are not being treated equally in the criminal justice system. This must change. And hence, the work of the Australian Human Rights Commission in this area and our report, Equal Before the Law, towards disability justice strategies, launched in February. It's on the Commission website if you haven't had a chance to look at it already. Today, we've put together a panel to discuss these issues with you. And it will be a discussion. Each of us up here will start with a few introductory or opening comments, but this Rights Talk will mainly feature interaction with the audience. And by that I mean the real audience and the virtual audience, because we'll be taking comments and questions from the room, but also from the Twitterverse. And we're live streaming this event, so don't turn off your mobile phones if you're here. Just tweet that you're here and that what's happening, and the hashtag is A2J, so A and the number 2 and J. And that way we can perhaps get more people following the live stream and participating in the process. So let me introduce our panel, who will discuss the issues and challenges surrounding access to justice for people with disabilities and explore some of the programs and services that have proven successful. So please welcome, and I'll go through them, not necessarily in the order that they're sitting here, because I think my notes on the seating plan for some reason don't match. But firstly, Mark Iris, SC, Senior Public Defender. Mark was admitted to the New South Wales Bar in 1981 and is a member of the New South Wales Sentencing Council and has been the Senior Public Defender since 2007. He has a long-standing interest in intellectual disability and criminal law, and he wrote Intellectual Disability, a Criminal Lawyer's Manual, published in 1989. In 1984, he was seconded to the New South Wales Law Reform Commission to assist the Commission with its reference, People with an Intellectual Disability and the Criminal Justice System. Please welcome Mark. Jim Simpson is also on the panel. He's the Senior Advocate for the New South Wales Council of Intellectual Disability. Jim's a lawyer and advocate who's worked in the field for 30 years, and he does systemic advocacy work for the New South Wales Council for Intellectual Disability. This has involved law reform, equitable access to the National Disability Insurance Scheme for people with intellectual disability who are in contact with the criminal justice system. And Jim also works on a number of tribunals. Please welcome Jim Simpson. Next is Assistant Commissioner Dennis Clifford, ASM, who's the Commander of the Greater Metropolitan Region of the New South Wales Police. Dennis has been with the New South Wales Police Force since 1971 and served in a range of areas. He's a highly commended officer, having received numerous commendations and citations. And he's the corporate sponsor for vulnerable communities and also a member of the Justice Disability Advisory Council. Please welcome Dennis. And lastly, but certainly not least, is Therese Sands, the Co-Executive Director of People with Disability Australia. Therese has worked for over 20 years in education, training, policy development and advocacy in the area of disability and human rights. And a key area of Therese's work is engaging with international human rights mechanisms to progress the rights of people with disability. Therese was coordinator of the NGO delegation for the first United Nations review of Australia under the Convention on the Rights of Persons with Disabilities, and she returned from New York yesterday, I think, having coordinated the young people's delegation to the Conference of Nations or the Conference of States Parties to discuss the Disability Convention. So please welcome Therese. Quite a hero, flying back from New York yesterday and on a panel today, I'll tell you what. Let me make a couple of introductory comments myself, and then I'm going to ask the panel to make some introductory comments. Negative assumptions and attitudes, coupled with a lack of support services, often means that people with disabilities are viewed as not credible, not capable of giving evidence, or are unable to participate in legal proceedings. As a result, many are left without effective access to justice. Since the release of the Commission's report, a number of state and territory governments have acknowledged our findings and are considering how they might develop disability justice strategies. Last year we identified 5 key barriers for people with disabilities. And once we've done that, we heard from victims, witnesses, those accused of crime, and those convicted as offenders. And the first barrier that we found concerned programs, assistance, and other community supports addressing violence, prevention, and disadvantage, which may not be readily accessible to those with disabilities. One submission told of Sarah, an Aboriginal woman with cognitive impairment, psychosocial disability, and health conditions. She began a long pattern of contact with criminal justice and human service agencies at age 12. And what became obvious was that there's a lack of appropriate support outside the criminal justice system, and responsibility for addressing her needs was often left to the police and the juvenile justice system. At 18, she was provided with 24-hour supported accommodation through a community justice program. Now, if Sarah had had access to community assistance from an earlier age, would she have had such continual action with the criminal justice system? I don't think so. Police services are often the fallback position in times of crisis, rather than appropriate community and health services. One submission said, and I quote, "The police have become the emergency mental health response for many individuals and families, and they are ill-equipped for that job." The second barrier dealt with the supports people may need to participate in the criminal justice process. Maria, for example, has cerebral palsy and little speech. She wanted to tell police about a sexual assault, but there was no communication support worker to help with the statement. The police relied on Maria's parents. Maria was uncomfortable giving personal details in front of her parents, not surprisingly, so her evidence was incomplete. And this caused problems for the investigation and during the court process. Barrier 3 concerned negative attitudes and assumptions about people with disabilities, which often result in us being viewed as unreliable, not credible, or not capable of giving evidence, making legal decisions, or participating in legal proceedings. We were told that, and I quote, "When I attended the police station, the police officer thought I was dumb at first, and he didn't take it seriously," unquote. We were also told, quote, "A victim won't even get their day in court, as the DPP won't run the case," unquote. The fourth barrier deals with accommodation and programs for people deemed unfit to plead. These people are often detained indefinitely in prisons or psychiatric facilities without being convicted of a crime. The well-known case of West Australian Marlon Noble is just one example of this. And it's one of the Commission's 20 Years, 20 Stories films, which are available on our website at www.humanrights.gov.au. And the last barrier concerns prisoners. Supports and adjustments may not be provided to prisoners with disabilities so that they can meet basic human needs and participate in prison life. This can result in delays and difficulties exiting prison or exiting exiting with successful chances of reintegration. Henry has an acquired brain injury. He wanted to apply for support from legal aid to appeal his conviction and needed help to fill in forms. He found the language complex and difficult to understand. He didn't receive assistance in prison to fill out the forms and fill them out incorrectly. This delayed his application, and by the time he filled out the forms correctly, his application was outside the time limit. And the statistics back up what we heard. 90% of Australian women with intellectual disability have been subjected to sexual abuse at some time during their lives. 90%, 9 out of 10. That, amongst a lot of shocking statistics, is probably the most shocking statistic for me. There are currently at least 20 to 30 people in our prison systems who have not been convicted of an offence, but have been found unfit to plead, and jails are the only accommodation option. From 1989 to 2011, 105 people were shot by police, and 42% of those people had a mental illness. It's women, children, Aboriginal and Torres Strait Islander people, and people from culturally and linguistically diverse background with disabilities who are even less likely to have equitable access to justice. And that's the basis of the report that we released in February of this year. So let me turn to the panel for their introductory comments before we get to your questions. So let's firstly hear some introductory comments, and perhaps Mark, you might like to start.
Thank you, Graeme. As can you hear me?
Yeah.
As Graeme has mentioned, I've got a particular interest in intellectual disability, but it extends also to other forms of cognitive disability, such as brain damage, and other disabilities such as mental illnesses. And the way in which we deal or don't deal with those disabilities in the criminal justice system. Graeme mentioned that I worked on the New South Wales Law Reform Commission major reference into intellectual disability in 1994, exactly 20 years ago. And unquestionably, there have been enormous strides made in that period in the way in which we accommodate such disabilities so as to neutralise inequalities and hopefully to achieve a way in which everyone can participate without any disadvantage. But sadly, in some areas we have a way to go. And you could perhaps categorise those as being in relation to the law, that is the law itself and the law as to criminal procedure, and secondly as to education. An example with the law relates perhaps to the fourth barrier that Graeme mentioned, which had to do with fitness to plead. And Graeme mentioned that in the context of accommodation and programs. I would add to that not only the issue of fitness to plead in respect of someone with a disability, but also the plight of those who are found to be criminally not responsible for what they've done because of their disability. As the situation stands in New South Wales at the moment, probably in most cases where someone is found unfit to be tried, and then there's a mechanism to determine if they did the acts they're charged with, after which they're detained in custody against their will, although they're not criminally responsible, and also for those who, whether they're fit or unfit, are found at the time of the alleged offence to be not criminally responsible. All of those people, in fact, spend more time in detention, and detention in New South Wales, unfortunately, means jail, which is only where you should be if you're being punished. They spend more time in detention than if they had been fit or they had been criminally responsible and found guilty. Now that's appalling, and the New South Wales Law Reform Commission has recently completed a further major reference in relation to this whole area, and it's to be hoped that their recommendations will be followed by government in such a way that this is perhaps astounding is not too strong a word, inequality can be neutralised. It's reached a point where defence lawyers, although this is supposed to be a non-adversarial area in the practice of criminal law, are reaching the point where we'll have to advise our clients, even though they can't fairly partake in a normal trial, perhaps they should anyway because of the awful consequences if they're found unfit. I mentioned also there's still work to be done in the area of education. With education, it's not a one-off measure that you take and that's it, done and dusted. It's something we have to reconsider all the time. Are we educating lawyers coming through law school? Are we educating judges? Have we done it in the last 6 months? And still, sadly, after 20 years, we see inappropriate results in the criminal justice system simply because a disability was not identified. Sometimes that's not brought to the attention of lawyers or the court. It may even be that the person with an intellectual disability is not aware that that's what they have. But having said that, it's not that difficult to come up with simple steps that lawyers and judges can take, especially lawyers, to figure out whether a witness or an accused or a victim may have an intellectual disability, and then to organise for a psychologist to do a report. And it can be as simple as asking that person in conference to explain back something you've just said, which has some abstract concepts in it, in their own words, so they're not parrot fashioning it back. And if they can't do that, it's time to go and see a psychologist. So just a few matters I've highlighted. Thank you, Graeme.
Thanks very much, Mike. Thanks, mate. Dennis, let's go to you next.
Yeah, thank you. Good morning, everyone. I'm obviously here representing New South Wales Police Force. Any opinions, comments I make are based on my experience and knowledge of policing in New South Wales. In New South Wales, we have an internal structure called the Corporate Sponsors Program, and a senior officer is assigned responsibility for a portfolio of some significant issue. My area of responsibility in that program is vulnerable communities. Vulnerable communities includes people who are homeless, the elderly, people with disabilities, both physical and intellectual. Often people fall into all three categories, and the situation is often complicated by drug and alcohol abuse. Often the police are the first point of contact for the criminal justice system when dealing with either victims or offenders or witnesses. Often police are the fallback or default service when other community services or health services are not available, and especially in remote or rural areas. Another complication for us is when people don't readily identify with having an intellectual disability or cognitive impairment, and it's not obvious to the responding police. In fact, we've had cases of people going right through the system and not being identified or diagnosed with an intellectual disability, and so unfortunately they end up in a prison somewhere. In my time in this portfolio, that's over the last 8 years, I've concentrated and focused on two main areas: the area of training and the area of networking, both with community and other agencies and support groups. In relation to training, it starts at our recruit level. And recently we've reviewed and revamped our vulnerable community training in all our modules across our recruit level training. We also developed packages for police to train at the local area command level, and that's both with input from our community sources, our contacts, and our Disability Advisory Council. Our Safe Custody course includes sessions delivered by the Intellectual Disability Rights Service, the Brain Injury Association of New South Wales, New South Wales Institute of Psychiatry, and other resource groups that work with us in that training. And those courses are run twice a month, every month, because it's critical for us that, as I mentioned, our first point of contact is generally the responding police, but the people who are experienced and hopefully the better trained to deal properly and fairly with people, in this case who come into custody with an intellectual disability, are our custody managers in the police stations. Our vulnerable community training also is included in other courses, so it's not just, I think as Mark mentioned, it's not just here's one part of training that'll solve all the problems. We engender and include that type of training in a number of our other courses, including our Detectives Education Program, particularly in relation to interviewing techniques, our domestic violence courses, and our youth liaison courses, just to name some. And our courses include scenarios based on disability and cognitive impairment situations. In my view, aside from training, our networking is just as important, both at the state, region, and at the local level. And our local networks are critical. The question we often pose is, who do you call at 2 AM for assistance and advice? And often If you don't have somebody at the local level that you can call on, you have nobody. We've established senior sponsors and advocate officer in each of our 6 geographical regions across the state. They're all at superintendent level. And in each of our 76 local area communities, we have an inspector with that vulnerable community portfolio. Part of that responsibility is to establish those local networks that I've mentioned a couple of times now, from both agency and community groups. In most cases, it's community and volunteer groups that are so critical, and they're the groups that we depend on greatly in those local communities. For our victims, we also have support units that can assist with interviewing in difficult situations, including our sex crime squad and our child abuse squad. They have expertise and experience in interviewing people, often with serious intellectual disabilities, and they're there to provide advice and support to detectives at the local level as well as their own investigations. And as far as preparing matters, briefs for court, what is so critical for us too is where it's perhaps a one-on-one situation where you've got a victim and an offender to establish if there's any corroboration, and often that will be in the form of evidence of DNA, for example. And with that technology, we've made some great advances and had some successes in prosecuting some difficult matters. We'll continue to review our policies and procedures to ensure our best response to people with disabilities. It's an ongoing process. We'd like to think we've made a lot of progress in this area. Still a lot of work to be done, and we'll continue to do it. Thank you very much for the opportunity.
Thanks, Dennis. Thanks, Dennis. Now, we've heard from 2 of our panel members, but you can start tweeting your questions now. Even if you're in the audience, you can tweet questions rather than asking them yourself. And just remember that hashtag A2J when you send your tweet. So, Jim, would you like to add your thoughts to the contributions?
Thanks, Graeme. What I want to focus on is the human services issues. As Graeme highlighted, so often the difficulties that people with intellectual disability have, and I'll be talking mainly about intellectual disability because that's my area of expertise, but a lot of what I'm saying I know has much broader application. But all too often people with intellectual disability get into trouble with the law, end up in jail, not because of any outright willfulness, but because of lack of the human service support needs that people, the lack of meeting of the human support needs that people have to help them keep out of trouble, keep out of jail. Now, in New South Wales, we've made some substantial progress in relation to those issues over the last 10 or 15 years, and it's important to acknowledge those. But in New South Wales and right around Australia, certainly many people with intellectual and other disabilities are still ending up in jail because their support needs are not met. The NDIS is a real opportunity, I think, to squarely address the support needs of this group. And if that's going to happen, then the NDIS and those administering it really need to squarely be thinking about this group as well as so many other groups in relation to all the areas of system design and implementation. To assist with that, my organisation have put out this guide, Participants or Best Policed, which is a guide to the role of the NDIS with people with intellectual disability in the criminal justice system. It's a step-by-step guide through the NDIS processes, and it's on our website. Let me just highlight 2 or 3 of the really key issues. The first one is engagement. I think the NDIS was established on a general assumption that people with disability or their family supporters would come and politely knock on the door of the NDIS office and either politely or hopefully very assertively as well say, look, hey, I need some support, or my family member needs some support. Well, this is very unlikely to happen for people who are in trouble with the law. They're unlikely to know about the system. They may well not identify with having a disability. They're likely to be from their whole life experience, they're likely to be quite suspicious of government agencies with which they've had negative experiences through their lifetime. So what's needed at each step of the NDIS process, right from the step of assisting people to seek its assistance, is an engagement process. Engaging with the person, getting the person's trust, and assisting the person to see, look, hey, maybe there is something useful that I can get out of this new system. And that's an example of that. The Intellectual Disability Rights Service in Newcastle have trusted relationships with lots of people with intellectual disability who get into trouble with the law. And those trusted relationships occur because they provide a system of support for people in police interviews and in courts. They've been quietly assisting a number of their clients to get the benefit of the NDIS in Newcastle. And that has been squarely founded on the fact that the individuals concerned have trusting relationships with the Intellectual Disability Rights Service staff. So we need to look at how to make that a much more generally available thing, assisting people to see the benefits of the NDIS and get the benefit of it. The eligibility guidelines of the NDIS, very, very pleasing to see that the old problem we had of a very strict focus on whether someone had an IQ below 70, the NDIS aren't too hung up on that. However, in assessment of functional capacity, we're going to need to watch very carefully that the NDIS doesn't set the bar too high or too arbitrarily for the group that I'm talking about to get the benefit. Thirdly, avoiding arbitrary demarcations between the NDIS and the role of justice and health agencies. And when I say that, for example, here's one that's already in the NDIS operational guidelines. They're saying that it's the responsibility of justice agencies, not them, to address offending behaviour. Now, that's a very arbitrary and loose distinction. Behaviour that we often will call behaviour of concern or challenging behaviour magically becomes offending behaviour because one of Dennis's colleagues decides that he or she has to intervene with the situation. It's such an arbitrary distinction. Secondly, the justice system only has very limited capacity and very limited mandate to provide programs to assist people with their offending behaviour anyway. I think Tier 2, that so far fairly empty space that's called Tier 2 of the NDIS, is an area we need to concentrate on. That, I think, is where there could be earthy local services that people who have trouble with the law could identify with, could just see as a place where I go with my problems. And that could then translate into building relationships of trust and seeking to become participants in the system. I better stop there, but thank you, Graeme.
That's great, Jim. Thank you very much. And finally, let's turn to Therese Hans.
Oh, thank you, Graeme. I suppose I wanted to touch on some points that have already been made. But firstly, I just wanted to thank Graeme for his commitment and dedication to investigating this issue and putting it on the agenda, because it's a challenging and complex topic, but access to justice for people with disability is often denied in many ways, and it infringes on many of the human rights contained in the UN Convention on the Rights of Persons with Disabilities. I suppose firstly I just wanted to make some additional points perhaps to Jim in relation to the National Disability Insurance Scheme. Some of our concerns at People with Disability Australia also is about how the NDIS will intersect with justice issues or people with disability who come into contact with the criminal justice system. We're quite concerned about that, and it's great that Council for Intellectual Disability New South Wales has produced a guide. Many of the people that we work with at PWD have, we're a cross-disability organisation, but many of the people have quite complex support needs, many different and multiple impairments, and pretty much the service system doesn't generally work with them. So they often fall through the gaps because they may need services or supports from the mental health system, the disability support system, the housing system, child protection, drug and alcohol, violence prevention, and trauma counselling, etc. So what we find is getting services and supports wrapped around people is very difficult so that people can actually be supported. And I think that Graeme illustrated that with the story of Sarah, who from the age of 12 was in constant contact with the police and juvenile justice, and then really it was only in her adult life when she received 24-hour support from a community justice program that she actually got the support she needed at that point. So in terms of the NDIS, we are concerned about how it will interact with the whole range of service systems to ensure that people get the support they need. And then the other issue is that not everyone will be eligible for the NDIS. They may not know about it, they may not identify as having a disability, and what those people we're concerned about, well, where will they get the support from? Now this is a particular concern when we have governments who are withdrawing from disability support service provision, which generally, if there are programs around the criminal justice system, often they coordinate that role through other service systems. But if they're withdrawing from providing disability support services and talking about their funding going to the Commonwealth, and that particular focus or location for that expertise, we're concerned where that will be located. It's highly unlikely that an NGO or private provider will want to take on people with quite complex and high support needs. So that's one concern. The other concern is in relation to the whole issue of violence, abuse and exploitation of people with disability, and the significant number of people who never receive any redress through the criminal justice system. And again, Graeme spoke about people who are not believed, not seen as credible witnesses or reliable witnesses, but it also can be the result of people living in particular service systems where these incidences aren't reported as crimes but are merely reported as service incidents that are left to administrative or policy redress. I think that is a particular issue that needs attention in terms of prevention of those crimes in the first place, because there's a higher incidence, and as Graeme again illustrated through that statistic of 90% of women with intellectual disability experiencing sexual assault in their lifetime, there are other statistics that show that people with disability, particularly women with disability, are highly likely to experience violence. So I think there's a number. The UN has also made recommendations to Australia to urgently address that issue of violence, particularly in institutional environments. And but we also need to do better in our national disability strategy, which talks or acknowledges the incidence of violence, abuse and exploitation. But largely the only action to deal with it is a reference to actions within the national plan to reduce violence against women and their children, which, it's great to be looking at other strategies in that way, but that is not a comprehensive or a systematic way of dealing with the significant issues in relation to violence. I think some of the other issues around receiving access to justice for people who experience violence, it may be that even where the police provide an appropriate response to a person, they cannot provide the other supports required. So, for example, recently we had a young woman with disability who was homeless, had been placed in a motel, was raped in that motel by another person staying there who then had moved on. She'd reported it to the police. The police had acted appropriately, but what she now needed was referral to sexual assault clinics. She needed trauma counselling. She needed appropriate housing. She was living in a rural area. She needed to be able to move out. That is something the police can't deal with. So the issue of human services and social services being connected to police, or for appropriate referral points for police to go to assist someone, is also critical. The other issues that I wanted to talk about were in relation to diversionary programs for people with disability. And again, this is around the fact that the justice system can see the need for diversion, but if there's nowhere to refer a person to in the social service or human services area, then it becomes very difficult to do anything other than detain that person. And finally, just touching on Mark's point, I think the whole law reform issue around Article 12 in the Convention around equal recognition before the law, meaning that people with disability should benefit from the law, but they should also be able to exercise their legal capacity. I think this has implications for a whole range of law reform in terms of voting, being able to enter into a contract, sit on a jury, etc. But it also has implications for fitness to plead and people not being found criminally responsible for an offence. And so we're keen to see the outcomes of the Australian Law Reform Commission review into equal recognition before the law for people with disability, and hoping that it will bring a significant change so that people don't end up being detained or not, not protected by those provisions, because at the moment they don't act to protect, as Mark pointed out. Thank you.
Thanks, Therese. Now comes the opportunity for questions and discussion. We'll take questions from the audience here and from Twitter using the hashtag A2J. But let's go to Priscilla first. We've got some questions from the audience.
Liz Daub, relationships and private stuff. I worked with a 13-year-old who played with the penis of another student at school and had been expelled. When the parent approached the school for the PDHPE syllabus that might have taught the child the appropriate ways to deal with puberty, they looked at Mum as if she didn't know what she was talking about. And I really think if the teachers were given the education at high school, then IDRS and the jail system wouldn't be seeing some of these students who don't know why their penis is standing up when they're 13, 14 because of the hormones. Any suggestions? How can we upskill the teachers?
Thanks, Liz. Jim, Therese?
I totally agree with you, obviously. It's curriculum design and training of teachers, I guess, and that's something that we all need to be pursuing with education authorities.
Look, I agree with that as well. I think sometimes the issue around inclusive education and segregated education can also play a part. But generally speaking, I don't think, often people with disability, including children with disability, aren't seen to require sex education or education around relationships or growing up or all of those things that other children may be educated about in the education system. And this really is detrimental, particularly as we find children with disability growing up and may not, and don't understand those issues, when in fact this then means that they don't understand what's inappropriate, what's unhealthy and what isn't, and it can lead to vulnerability to abuse. Really.
If there was more education, there'd be less victims as well.
Yeah. I think that's the point that you're making, and I think it's a very powerful point. I mean, and it's broader, isn't it? It's all about diversionary programs which keep people out of the justice system, and that was certainly one of the concerns in our report. Let's take a question from Twitter. Penny, have we got?
Yes, we have Evan Wallace, who comments or asks for a comment. Access to justice is tied to addressing perceptions toward disability and raising awareness. Could you comment on the huge challenges this presents in rural and regional areas?
Let's start with that. I mean, I'll say a couple of introductory things if you like, and then happy for the panel to comment. I mean, it's a huge challenge, access and awareness around disability, and recognising that the fact that disability causes impacts at different levels and causes different impacts. And several of those stories that I told in my introductory comments were in regional and rural areas. It's always easier to roll out services and programs such as those on the database that the Commission is putting together to try and give people better access to justice pathways in urban areas. And we found all around the country that rural and regional areas were disadvantaged as a result of that. So I think that's a big challenge. Anyone else like to?
Yeah, if I could add, Graeme, one of the problems we see in some of the smaller communities is reluctance of people to come forward and report crime or even identify with having intellectual disability because of the perceived or the real stigma attached to it. And it's very difficult in those smaller communities to get people to report crime, but also for witnesses to come forward. I don't know what the answer is. It's not simply a matter of relocating people to another community, and you relocate the victim or defenders, and it just the problems we find in the city are just exacerbated by that tyranny of distance, I suppose, away from where most of the services are located in this case in Sydney and the other major capitals. But it's a real problem in the rural areas. It's encouraging people to come forward and get that help.
Graeme, sorry, if I could just add, one way that we've approached that issue is working with educators and individual advocates to go into regional and rural areas and to speak to communities and to discuss issues on a whole range of topics. And as issues arise for a person, there is someone there that can be actively engaged with the person to discuss, referral points or discuss the issue of what may be required at the time. So I think there is a role for outreach of some kind into those communities.
Thanks, Therese. Priscilla, next question.
Thanks, Graeme. I am a blind and ethnic person in the community. I want to share an experience with you. On jury selection, a few years ago, I was selected to go on a rape case. And the judge wants to excuse me. And he said, no, you don't have to participate. But I insisted. I said, look, I'm a social worker by trade and a mediator. Then only he accepted it. Now, is that the case? Because if you are intellectually disabled, then you would definitely not go on it. Secondly, on a wider issue, Graeme told us that at the end of this month is not going to be the commissioner. Will there be a replacement? If not, why, if we consider that disability issue as important, why does the human rights do away with it? You have other commissioners, the agent, Aboriginal, and recently a freedom commissioner in the name of Tim Wilson. Now, surely one of the commissioners could do the work that he has undertaken without having to give him such an exorbitant package in the eyes of restraint. Thirdly,
can we just stop you there, because I know we've got a lot of questions. We might just take those first two questions.
Can I have a quick comment?
If we've got time, we'll come back to your third point. But because I want to get through as many questions as I can. On your second point, and thanks for those questions. On your second point, question of who's appointed to the Commission is a government decision, and the Attorney General has decided that my role won't be filled by a full-time commissioner when I finish on the 4th of July, and that one of the current commissioners will act as Disability Discrimination Commissioner as well as doing their current job. The Commission have also said, some of you may have read in the media, that they'll be spreading the work around amongst other commissioners so that there will be more of a sharing of the disability portfolio. So yeah, that's a government decision. It's part of the budget, and that's the response to it that the Human Rights Commission has made. So I'm sure that the Human Rights Commission will try to do as well as it can with the hand that it's been dealt. Let's go to your first question now, and I'm just not sure, Mark, whether you'd like to comment on the jury.
Yeah, I'd be happy to do that.
Sure.
It's a very interesting question. First of all, I imagine that if a member of the jury panel indicated to the sheriff that they did not want to serve on the jury, that they would be excused. But your question raises the idea of what if they do, and could they? In relation, firstly, to an intellectual disability, because you specifically mentioned that one, I think it would be very difficult for someone with a mild disability or moderate disability. It would be possible, I think, for someone with a moderate disability, but it could be possible for someone with borderline. But in order for that to work, the court would need to be informed that one or more of the jurors had a borderline intellectual disability, so that the language, that is what's spoken by the barristers, prosecutor, defence counsel and the judges, could be appropriately qualified to avoid, wherever possible, abstract concepts. And you'd have to have some mechanism which would enable the juror to indicate that they haven't understood something that's been said. So with those qualifications, I can see how that could work. Blindness, sight disability, would depend on the particular trial. If the trial involved some form of visual images which were important in themselves, which required a degree of judgment by the juror, which might, for example, be identification evidence and photographic evidence as to whether this person was that person. The juror with a sight disability would not be able to perform their function properly as a juror. But again, if the juror indicated that they wished to be part of the system, then it would be a matter for the judge to say to the parties, to the defence and prosecution, what's the evidence that's anticipated in this trial? Does any of it require the jury to make an assessment of evidence involving sight? And if it didn't, then I would see no reason for that person to be excluded. In terms of, there would have to be some other steps taken. For example, if there's to be a transcript or other documents tendered, they would have to be put into a braille form or whatever, or to be heard. So I don't see that as being a barrier.
So Mark, can I just pursue that for a minute? Does that mean that, you may or may not know this, that the Law Reform Commission's recommendations have been taken up in New South Wales, and that people who are blind or people who are deaf can now serve on juries? Because for a long time, they were automatically excluded.
I haven't had any personal experience of those issues arising, and nor have any of the public defenders informed me of the case where they've had that as an issue. So, Graeme, I don't know.
No, okay, well, I might need to check that up as well.
Graeme, can I make a quick...
No, I'm sorry, I want to share the questions round, and I'll come back to you if we have time. I'm sorry, but I think we'll get through that soon. Jim, yeah.
On that issue of juror, who could be a juror, I don't know exactly what the law says now, but what I think the law should be saying is that to be eligible to be a juror, the question should be whether, with appropriate support, someone is able to fulfil the functions of a juror. Now that might be a revolutionary thing in the law to bring in the idea of, for example, a person with intellectual disability having a support person in their role of juror, but that to me is a logical and reasonable thing. The other thing that Mark touched on, and I think this is really relevant to a whole range of issues about accessibility of the legal system for people with disability, is that the law overall, I think, needs to sort of cut down the alienating mystique that courtrooms involve. And that's partly a matter of doing away with some of the peculiar customs that that would alienate sort of so many people when we go into a courtroom, but also doing a whole lot to bring back everything that's said in courtroom to plain English, rather than the ridiculous tortured use of English that we lawyers so often thrive in.
Yeah. Thanks, Jim. Let's take another question from Twitter, if we could, Penny, please.
Yes, Graeme, we've got a lot of comments coming in from Twitter and 3 or 4 questions, such as Jara, who asks, are provisions of the Evidence Act permitting people to give unsworn evidence, are they often used, or are they used effectively?
Mark, yeah, I think that's yours.
Yeah, one of the welcome additions to the law of evidence in the Evidence Act in 1995 was a provision that allowed a witness to give evidence where they were otherwise, to use the convoluted legal term, not competent. In other words, where a person did not understand the concept of giving truthful evidence, that meant they couldn't give sworn evidence, but they nevertheless were able to give evidence under the Evidence Act. Now, what happens if a person's found unfit to be tried, and if they also are not competent to give sworn evidence? At the hearing that takes place after the finding that they're unfit, which looks like a normal trial to all intents and purposes, including having a jury, if they're not competent to give sworn evidence, they can still get in the witness box and give evidence without being sworn to do so. In my view, it's second rate. It's second rate because it doesn't have the same weight attached to it that sworn evidence has, because the fact finders, the decision makers, take into account that they haven't given that evidence on their own. So it's important that a person be competent to give evidence if they're going to be fit to be tried. I wouldn't like to see someone with intellectual disability who's charged with an offence being allowed to partake in a normal trial and face perhaps a lengthy custodial sentence if their evidence isn't going to be given the same weight that someone without an intellectual disability, their evidence would be given. And that, to hark back to what I said earlier, is all the more reason why we have to fix up the mechanisms that apply to unfitness.
Thanks, Mark. Did anyone else want to comment on that question? Okay. We might go on to another question from the audience. Priscilla.
Yes, I've just got a question about the balancing between believing somebody's disability and believing that they might be trying it on. Forgive me if I'm showing some growing up in Queensland baggage here, but on the ground, I would say that there's still a fair bit of, I guess, of an adversarial relationship between police officers and someone they're confronting. And as to, in particular, as to whether they believe that a person is, for example, hearing impaired or vision impaired if they look in their eyes and they don't look blind. Mm. Some time ago there was a fairly public case which revealed in court a young constable claiming that the defendants were actually drunk when the barrister had to point out to them that there were 5 artificial eyes between the 3 of them.
Mm. Yep. No. Dennis, would you like to start with that, although other members of the panel might want to comment as well?
Yeah, sure, thank you. Look, I've got no doubt there are people out there who claim they have a disability when they don't, just as there are people who won't identify with having a disability or try and disguise that they have a disability. And that's the real challenge for police when they're interacting with people who are either victims or offenders, and even with witnesses. Some of the stuff we've done with some of the support groups is to be able to call on them to support a claim. Like, for example, with people with an acquired brain injury, we had some discussion with the Acquired Brain Injury Society, I forget the actual term, last year, where they were going to, or have set up basically a database that we can give them a call if somebody says, look, you know, I have this brain injury, if you call this number, they'll verify who I am and what my background is. So that's the sort of resource and networking that we're trying to achieve. And of course, making other inquiries with family members, with other groups that can verify, substantiate the person's claim, in this case, that they have a disability.
Thanks, Dennis. Teresa, do you want to comment on that, or others?
Look, I can't say that we come across cases very often, or people with disability who, or without disability, trying to claim they have a disability. I mean, the main thing we come across is people with disability being believed in terms of their story. That is really, you know, the majority of issues around credibility and being believed, or even being. If a person, particularly if they're living in a institutional facility or a segregated environment or boarding house, etc., something that where police may consider that it's not really a police matter, it's a matter for the service system to deal with the issue that the person is raising. So it may be an issue of violence or abuse, and they may have come to the police to report it, but they'll get taken back to that facility to be, because they're seen to belong, if you like, to that system and not actually to the police system. But I haven't come across that as much, at all, really.
Yeah, thanks, Teresa. I have to say that my experience with the consultations that we did reflects that as well. That the issues that we had were people being believed and people being recognised as having a disability. Any question, please?
Leon asks if states offer Auslan interpreters for witnesses or defendants with disabilities.
Jim or Mark, do you want to? Don't know.
I could start from police perspective.
Yeah, sure.
We've got access to Auslan interpreters through the normal interpreter service. Same as we would apply for someone with a foreign language, if you like. We can contact Auslan interpreters to assist with either taking a statement from a victim or interviewing an offender. We've also recently put posters into each of our stations now, so that somebody comes in hearing impairment or deaf, they can actually point to diagrams on the chart to get the message across to the police officer behind the counter.
My understanding, thanks Dennis, my understanding is that courts in New South Wales at least do provide Auslan interpreters for witnesses and defendants. But there was an interesting case, just to go back to the jury issue, in Queensland just 3 or 4 weeks ago, where a woman who was very prepared and keen to serve on a jury, and she lip-read quite well, but she actually asked for an Auslan interpreter, and immediately that request was made. The judge ruled her out of participating on the jury on the basis that there was a problem with having a 13th person in the jury room. So that was got quite a lot of publicity. I don't know, Mark, whether you or others want to comment on that.
I'll just make this comment that if we're going to be serious about this, it might be appropriate to revisit another aspect of criminal procedure, which is that the defence and prosecution have an unfettered right to challenge, the word is challenge, any proposed member of the jury without giving any reason for doing so, and typically there are 3 challenges each. So it may well be you get to the point of the jury being sworn, and then the Crown or defence challenges that juror. I think that really emphasises the need for legal education, as Graham's anecdote does as well with the bench, and there's clearly a need for that.
Thanks, Mark. I know some people may have to go. We are going to finish in a few moments, but if we've got a couple more questions, Priscilla.
Thank you. My name is Alex, and I manage the Criminal Justice Support Network at the Intellectual Disability Rights Service, and we're the main service that sends support persons to police stations for people with intellectual disability. And I mean, we see some very, very good custody managers. I think a larger proportion are ones that are not so good. A lot that we see are just sort of trying to do the right thing. But I'm wondering if there's any scope for more involvement of organisations such as CJSN and PWD and CID in police training. I mean, I know that we're only involved in the custody manager training. We come across an awful lot of custody managers that haven't done that training, or if they did, they certainly weren't listening, because they will call us after they've processed the person, almost as though they're just reporting them to us. Way too late for legal advice, too late for a support person, all that sort of thing. So I'm just wondering if there's an opportunity there for some better, sort of more engagement across more police areas of organisations like mine, like CID and PWD.
Dennis,
yeah, that's yours. Thank you. Yeah, fair question. As I said before, we've come a long way to go.
Yeah, absolutely.
We're rolling those courses out twice a month, not only as new training courses, but also refresher courses. We've been doing some work with Mike from the IDRS to have a look at the stats that IDRS hold compared to ours, and looking for areas where there may be a number of cases where IDRS have not been called, and look for the reasons why. And as you know, there's a lot of reasons why IDRS aren't called. Yes. Legitimate reasons, but in areas where we're finding that they should have been called and they're not, we're speaking to those commands and either retraining the officers or reinforcing the policy.
So I should have a bit more of a chat to our chairperson about how we can become more engaged in that.
Yeah, sure. Yeah, quite happy to talk to you later about that.
So I'll just make a comment in relation to that. I think it's a serious issue that needs more work done. I had first-hand experience of a case where a suspect on a murder charge with a moderate degree of intellectual disability was the subject of a police interview where there was no need for haste, where they were made aware that the person had an intellectual disability. The family made that clear, and the police response was to have a family member sit in. So that wasn't appropriate at all. That would in fact simply have encouraged the person to be forthcoming by virtue of the fact that there was someone they knew sitting there, which isn't, I don't think, what's required in terms of an independent role in that regard. The person had demonstrated their lack of understanding of what was going on and what their rights were, where not surprisingly they gave inappropriate answers to the standard questions at the end of the interview as to whether any inducement had been offered, to which he replied cheerfully yes, until he realised that was the wrong answer, so then he tried no. So there's more work to be done.
Thanks, mate. Priscilla, more questions?
Thanks, Graeme. As a lot of people have already said, people with disabilities are also very vulnerable to being victims of crime, particularly women with disabilities, but all people with disabilities. And I wonder if in preparing the research and the report, you and what the panel knows of how people, with their interactions with government, for example, the police, as Dennis said, they're often the first people to come in contact with people with disabilities. People may have had very negative interactions with government, for example, police, who I recognise have a very difficult job, and how and whether that affects people's ability to then report crimes when they've been a victim of crime. And it is, I believe, in my work, that's caused a bit of a problem for a lot of people because of really negative experiences with police and other aspects of the criminal justice system.
I certainly, thanks Daniel for that question, I certainly came across a number of instances when we were doing our consultations where exactly that was the case, where people did have a negative view of police and the legal system based on experiences that they had had, and they were reticent to report crime when they were the victim of crime as a result of that. So I think there's an issue there without a doubt. I think you put your finger on one of the problems we need to address. Would other members of the panel like to comment?
Well, only to agree, really, that is the case. And why the issue of support for people is critical, and education and training for police is critical. I mean, that is absolutely the case where people have report because of bad experiences that they've had.
And Therese, I'm right, aren't I, that the research that that you and others have done indicates that women with disabilities are less likely to report violence, physical, or any form of violence, including sexual violence, than are women across the board. Is that right? Or have I confused that?
Well, that is the case. There's a range of reasons for that.
Sure.
And one of those may be sort of previous negative experience, but there are a number of other reasons.
Sure.
For that.
Yeah.
Can I also add that, unfortunately, far too often people have minor contact with police, and that leaves a negative view in their mind, gives them a negative experience where perhaps police are called, or it's not appropriate for police to deal with the situation. You know, the child in the school that was inappropriately touching another person, they say the next phone call, or maybe the first phone call, will be to the police. So in that child's mind, I'm in trouble, there's the police. It's a negative view of the police. Now, we'd be the first to say we don't want to see anyone in custody that shouldn't be in custody. Anyone in the system that shouldn't be, if there's an alternative, a diversion, an early diversion through whatever means, so that that we don't have people in custody because they have an intellectual disability. One doesn't necessarily follow the other, but it's far too often the case that the first experience people have with the police is a negative contact because there's no one else to call.
Thanks, Dennis. I know people do have to get away, so I understand if you do need to speak. We might just take one more question from Twitter, if you've got one, Penny, and one more from the audience.
We have a lot of comments that follow up on the lady in the front row's question. Such things from NCOS, community and advocacy organisations are essential to responding when a person with disability comes into contact with the criminal justice system. There's a lot of comments along that line.
Along that line, yeah. Okay, well, I mean, I think that will get broad agreement from most of, if not all of the panel and the audience. And but of course, it's always for community organisations, particularly an issue of resourcing and capacity. But all right, have we got one more question from the audience, Priscilla, before we?
I'm sorry, Vanessa Miller from the Community Justice Program, and it's more than asking a brief thought. We deal with the other end of the service provision, so the service provides support for intellectually disabled offenders coming out of custody back into the community. So and it's also voluntary. So then it's not an option. And I'm wondering whether or not there's been consideration to providing that as a diversionary program, so people with IDs don't end up in the custodial setting, that they are, I don't want to use the word mandated, but they are encouraged to participate in remaining in the community with more services provided, or alternatively making that part of a condition on the lease, because we do find that as they come out, very quickly drop off because it is a voluntary program.
Thanks, Elizabeth. Mike?
Yeah, I've done about voluntary. My experience with CJP is that, firstly, in relation to forensic patients who are conditionally released back into the community, that CJP programs are often a condition of them being released. And in relation to prisoners who have an intellectual disability, it could be a condition of parole that they comply with reasonable directions given by the CJP. I just take the opportunity to say that such programs are really just so important. I think we probably in this room we all appreciate that for offenders who have an intellectual disability or forensic patients, that is people found unfit to be tried and subject to a limiting term or not criminally responsible.
Can I just take the opportunity to mention, and I briefly referred to it earlier, but one of the things that we did as the result of our report was that we put together a database of programs which would provide people with a better justice pathway, people with disabilities, and that database is now up on our website, and we have had quite a few submissions from around Australia adding programs to that database. It's not a detailed database, it's just the name of the program, one line what it does and a link, but it's an attempt to try and share resources and information which the Commission felt was a way to try and facilitate some better approaches in this area. That database will, in the next couple of weeks, move across to the University of New South Wales, so that once my term as Disability Discrimination Commissioner comes to an end, that will be continually available, and we'll be making sure that people are aware of that when it occurs. We're just in the final process of transitioning it now, because hopefully that will be a useful resource. The amount of times that I went around Australia in this consultation and said, oh, well, have you heard of such and such a program in New South Wales or Victoria? And people would say to me, oh, no, haven't heard anything about that. So we just thought this was a useful resource. So thanks for that question. I am about 10 minutes over time, so I do need to draw today's discussion to an end. It's been a fascinating discussion of what is a very complex and challenging topic. The justice system is a hard system to turn around, but it is a system where all of us need to work to continue to try and find equality for people with disabilities in the system. Thank you all for your excellent comments and questions, both you in the audience and you out there on Twitter. I never know where to look when I'm talking about Twitter, you know, sort of all around me. But please thank our panel today, Mark Irace, Dennis Clifford, Therese Sands and Jim Simpson for their contribution. And may I just say to those who I may not see before the end of my term as Commissioner that I've loved this job. I've loved working at the Commission for the past 8.5 years, well, 15 years if you count the time I was Deputy Disability Discrimination Commissioner. It's the best job that I've ever had. And you can be assured of my continued passion and commitment on disability issues in the years to come. So thanks very much for Thank you. And finally, can I just say thank you to the audience. I hope that your participation today will encourage you to continue to strive for better justice pathways for people with disabilities in Australia. And thanks for your participation today. Thanks very much.